All right, Bryan Kohberger exiting the courtroom following this morning's arraignment, where, if you missed it, he, through his attorney, decided not to enter a plea of not guilty. He opted to, quote, stand silent. And at that moment, the judge entered pleas of not guilty for him on his behalf. And they're moving forward now with an October 2nd trial date. We'll see if that sticks. Likely will not. Here to discuss it, trial attorney Lateef Gray in Oakland, California, and in Detroit, trial attorney Michael Jaffer. Welcome, both of you. Good afternoon. Michael, the October 2nd, let's start it there. Likely not going to happen, especially if the state comes in and says we are seeking the death penalty.
Oh, yeah, absolutely. October 2nd is only, 4 months away. This is a trial of grave magnitude. The nation is going to be very interested in it. 4, college students were killed and murdered, and he went to Pennsylvania. He was, arrested in his parents' house. It took them 6 months to extradite him from to Pennsylvania and get him to this point. So the trial is 4 months later, and it took them about 5 months to get him to this point. I would put the chances of a trial of happening on October 2nd at around 5%.
Lateef, according to our Chanley Painter, who was in the courtroom, Kohberger at one point when first walking in gave a quick glance into the gallery, but otherwise, as we watched, it was pretty much straightforward, not looking back. Family members were in the gallery, the Gonzalez family, Maddie Mogan's family there. Anything stand out to you in terms of his appearance, his, the fact that he elected to stand silent instead of entering the not guilty plea, which we expected?
Well, the fact that he didn't enter the not guilty plea, or his attorney didn't enter the not guilty plea, is a little bit different. Ordinarily, in these circumstances, when a client is entering a plea, whether it be guilty or not guilty, the attorney lets the court know in advance what the client will be doing. So the fact that his attorney didn't enter a not guilty plea on his behalf is a little bit different. The fact that he didn't look around and stayed straight ahead, that might be at the advice of counsel. I know usually when we come into court, we tell our clients, don't look around, look straight ahead, and let the court know that you're here for serious business.
The Parkland shooter, Nicholas Cruz, did the same thing. In Florida, it's called, instead of saying the defendant stands silent, in Florida, it's the defendant stands mute. And that's what Nicholas Cruz did, and the mentality behind that was that it serves as one of the mitigators, and that is remorse, because we know that Nicholas Cruz admitted to what he did and wanted to enter into a plea agreement with the state to avoid trial in return of dropping the death penalty. He would plead guilty. They turned that down. He ends up pleading guilty anyway, and they have the penalty phase where eventually he was not sent to death row. Do you think that maybe, Michael, that's the angle, that he is going to eventually plead guilty here, that might be behind why he chose to, quote, stand silent?
That could be. He clearly had a discussion with his attorney. This was an intentional act on their part, right? This is part of a larger plan and strategy that him and his counsel have put together. It could just be that his counsel told him the only way out of the death penalty is through this judge. It's not through a jury, it's through this judge. You're going to have to prove to this judge that you are remorseful, and this might be the beginnings of that play. We're going to find out soon, and for all we know, maybe that's why they put the trial date so soon, because maybe the court knows something we don't know. There is a gag order on this, so they might know something they definitely know something we don't know, and that thing might just be that this kid is going to end up pleading out.
But do you think, Lateef, the state of Idaho agree to a plea agreement, given the fact that they do have the death penalty on the books, and this, I can't imagine a crime worse, if prosecutors and family members want to pursue the death penalty, well, they likely won't want to enter into any sort of plea, correct?
Yeah, it just depends. I could see the state entering into a plea with this gentleman based on the fact that they don't want to put the families through a lengthy trial where they'd have to sit there every day. They may have to testify. They may have to hear evidence that is just gruesome. So I could see the state offering a plea in exchange for keeping the families from being further traumatized by having to listen and sit through a lengthy trial.
If that's where the family wants to go, Michael, some families do want that process. They want the maximum penalty allowed by law as a point where they feel as though they're fighting for their loved one.
Yeah, I mean, the victim's advocate definitely are probably involved in this process, right? If we're gearing up for a plea and the court knows that, and the attorneys have, because the attorneys take a sidebar with the judge, right? And they have open conversations with the judge. They don't admit to fault or anything, but they've telegraphed if they're going to plea. I would assume their attorneys have telegraphed this to the judge. The victim's advocate must be involved, and the families of these 4 kids, they're going to be heard by this judge, and he's going to care more about their opinion than the opinion of the defendant, if in fact he does plead guilty, and if in fact he did in fact do this. So the families are going to play a big part in sentencing. They definitely are.
The probable cause affidavit laid out the state's case in such a fashion that kind of really didn't need the prelim for the public disclosure of the strength of the case, Lateef, because it's there. I mean, they have him, they're tracking his vehicle, they're tracking his cell phone, and most importantly, the killer leaves behind a knife sheath, and guess what? This guy's DNA is on the snap of that knife sheath. It seems as though while he said through an attorney after his arrest that he looked forward to clearing his name, that enough time has gone by for a PhD student to connect the dots that, ruh-roh, I'm done. You agree, Lateef?
Well, I agree that there's a lot of evidence. Him saying he wants to clear his name, I mean, that's just, he has to say that at that point. I mean, he can't come in and say, I'm pleading guilty from the beginning of the case. So him saying he wants to clear his name and wants to fight the case, I expected him to do that. The fact that they've gone by way of a grand jury indictment lets me know that the prosecutor wants to get this case moving and wants to get some sort of progress made, either be a plea or taking it to trial.
Yeah, and that part of the equation there too was the fact that the defense wanted to, or they filed a motion for, they issued a subpoena for the 4th roommate, and they asked the court to require that individual to testify at the preliminary hearing, and it was shortly after that was litigated that the state went to the grand jury and they vacated the prelim because they didn't need it because a grand jury indicted him. So this is a 3-part process, very bizarre sort of thing happening today. You have the arraignment, which it was done. Now there are 2 other things on the docket, if you will, but they've taken breaks in between them. So next up is the scheduling conference on the gag order. You remember the Gonzalez family is, through their attorneys, basically asking the court to separate the families from this gag order, and they want the ability to discuss the case, and they believe that that's very important. So they're going to deal with that. And then there's going to be a 3rd hearing, a motion hearing on a defense motion to compel.